We're going to go ahead and get started. Welcome back from the holiday, whatever holiday or break, whatever it is that you may celebrate or not celebrate. I think I've covered everything with that now. But no, seriously, I hope folks had a good time. I am enjoying it much more now because I had a root canal yesterday that I needed pretty much the whole break. And so I'm really in a much better mood. So you're glad that I had that taken care of yesterday. So welcome back. I know we have Judge Young online and Judge Starring are as well. I'll give them a moment to talk, but I wanted to start just with a quick introduction myself about where we are, what's going on, and how things stand. Give me just a moment. I need to open something. I thought I had to, but I did. I know we're making this. I think it's important to recognize, and I want to thank Judge Bustamante in particular, because I know starting in November, she began holding hearings regarding the stayed cases and have made a great deal of progress. I'll tell you that we started with 95 appeals that we stayed since September. The Maricopa County Judge Bustamante started holding hearings in early November, November 1st. At that time, we had 55 appeals stayed and remanded. She's held status conferences pretty much every week. And by January 3rd, she found that DCS had completed its disclosure in those 55 original cases. And so they are not all, the stays haven't been lifted, but they are back with the Superior Court judge responsible. I know those judges are reviewing documents at the request, as requested by the litigants. And basically, there's real progress being made. There are more cases, and we are keeping Judge Bustamante advised of all the cases we stay. I'll tell you that the stays aren't over. And one of the things I would like to hear today is why we're still continuing to get stay requests. We've had stays in December. We've had 3 stays, I think, in January at this point. And that's a little concerning that we continue to stay cases, but I suspect there's an explanation, and it may have to do with the round of disclosure that was set to happen on January 3rd. And that hopefully we're going to start to see that wrap up. I will tell you that and so that folks know, from November, we stayed about 20 new appeals and cases. In terms of the cases that we have lifted, I thought I had that here. Sorry. I'm apparently not capable of operating my email on the fly. We've lifted stays in about 30 cases is where we're at of the ones that we have worked on. And I think we have at least 2 more motions to lift the stays. So about a third of the cases have started to move forward. I expect that trend will continue, and over the next month or so, 2 months, I hope to see that wrapped up because the disclosure is done, folks can file their motions, and we can get back. I will say, I know the microphone's here. I'm trying to speak loud. If anybody online can't hear us, please go ahead and send a note or wave, and we'll try and make sure that we can speak a little louder. So anyway, that's where we're at. I just want to give folks that because we are making progress, and I know sometimes it can feel like we're not. And we can't publish reports saying these are the cases they were lifted. We've got confidentiality issues. But I think it's important for people to know that progress is being made. The cases are moving forward. In some cases, they're coming back to us with, we don't need to do anything further. For example, I just had a decision, actually an opinion, that came out after the beginning of the year in a case that was stayed because they didn't need to do anything further. So I just want folks to know that that progress is being made because you don't always see it. You don't always know that. But some cases are coming back and we don't need to do anything further. Some cases, the folks are making motions and the judges are holding additional hearings on those matters. So that is a good thing. It's progress. And I really do appreciate that. So I wanted to make that point clear. Again, I appreciate that we have folks who are working. I know folks worked on it over the holidays, and my understanding is we've made progress, but we're going to hear from everybody. One thing that would be helpful as we go through this, and I know, Ms. Wright, you indicated you need to leave, so if you need to go first, that's fine. But if you or somebody else, if not you, can address why we're continuing to see stay requests in cases despite where we're at in this process. And again, they seem to be slowing down, but they are still coming up. And they're not just in Maricopa County. Some of them are in some of the other counties where we're still staying the appeals. So I think that's important. So why don't we go ahead? I want to first ask Judge Young or Judge Starring, who are both online, I should say that. Judge Young, is there anything you wanted to add at this point? Anything that you're experiencing, your thoughts?
You know, I'm continuing to hold status conference on the individual cases that have been stayed. And I have had some recent cases that were appealed that were stayed. And so I'm very interested to hear why these newer cases are still having issues. And so definitely very interested in that. But thank you, Judge Goss, for once again getting all of us together so we can talk about this issue. And that's all I had for today.
I'm going to continue to do this until it's over so we can continue to hold regular meetings, because in my experience, a meeting makes sure things get done. So nothing personal for anybody, but a meeting tends to get things to happen. Judge Starring?
I don't have anything significant to add. We have a pretty low number of cases that have been affected. I believe one that was stayed is now back into the briefing schedule, and nothing further needed to be done, according to the trial judge. And that's where we are. And I think, if I understood Judge Young correctly, as being an interested observer in these proceedings, that's how I describe myself today. Thank you.
Oh, thank you. And I think we all recognize there's a large portion that's really Maricopa County centric, statewide. You know, other counties are still being affected, but it tends to have a Maricopa County centric aspect to it. So with that, then, why don't I go ahead? And again, if you speak loud, if you see the green lights, those are where the microphones are.
Okay.
Next time, we'll probably set it a little narrower so that we're a little closer to the microphones. But Ms. Wright.
Sure. So to answer your first question, I think anytime you make a big system change and you put a lot of different changes in place, and that, especially when they are people-centric changes, it's going to take a little bit for things to catch up. So we've been asking for the affidavits. I had an attorney come into my office this morning and say, hey, the only thing that's missing is this month's case notes. Can I proceed on the severance trial? And I said, do you have the affidavit from the case manager saying that everything else has been disclosed and that's the only thing? And she said, yes. And my instruction was, make sure you let the court know that that's what's missing. If parents' counsel agree to go ahead and proceed without those, that's fine. If not, then we may need to ask for, for a continuance so that up-to-date information can be brought out. So those are the types of issues. So if the case manager doesn't feel comfortable signing that affidavit, then we are going to continue a case out. We should be seeing cases now come through that are being appealed that have the affidavit. So the number of cases that are needing to be reviewed is significantly lower. We were also waiting for the implementation on January 1st of the department's new system. Stephen can address that. So far, things are going very well. There are very few bugs. I'll let him address that more thoroughly. But getting that ease of disclosure to the people that are responsible for getting the documents out has taken some time. So I think going forward, we will not see nearly as many that we're requesting to stay on, but we are still there's like a blend of how the disclosure is getting sent out. And until we have this consistent format, which now we do, I think things will move significantly faster. We'll be able to track what has and hasn't been disclosed. We were in a meeting the other day, and I know Mark Evie, who carries the load for disclosure in Maricopa County, was saying that he's now being able to see where he can and can't track and can help the case managers realize what they have and haven't asked for. We haven't been able to do that up until this point in time. So it's just the processes getting put in place have taken some time, and we don't want to make mistakes. We want to make sure that when a case manager signs an affidavit and says everything's been disclosed, I mean, like I say, there may always be the one document you missed, but that the vast majority of everything has gone out. Everyone feels comfortable moving forward. The information's there for the parents, for the child's counsel, for the court, and we're doing it the right way. And so it just takes a little bit of time to catch up to that. We're hoping within the next month or so that we won't have to go back and do the review. And just to give you guys an idea of what the review is like, all hands have been on deck. TAC, certainly Ms. Kawamura, myself, we have all done redaction, review. I mean, some of the sets of I reviewed a set of 3,700 pages of emails. You can't do that correctly and make sure that everyone's confidentiality is being protected in 15 minutes. It took a significant period of time to get through that. So that's one of the slow pieces. But everyone collectively in the department and in our office tried to make sure that we met Judge Bustamante's deadline, and Ms. Calmer spent much of her break making sure that happened. So we are
I did work on this break too.
Yes. So we are making significant progress. Like I said, though, I think it's just a matter of implementing a bunch of different changes and having them catch up to one another, and so that we're all moving forward in the correct manner.
I want to add another shout out for folks, and I know it's weird to call it a shout out, but I mentioned Judge Bustamante, but all of the juvenile court judges are doing a Herculean job. Judge Young, I'm certain, has faced this. They're reviewing 3,000, 4,000, 5,000 pages of additional disclosure and putting in extra time. And it's a tough job to begin with, to manage a juvenile calendar. So I appreciate also the Superior Court judges who are doing this, and the AGs and the other folks who are working on it. I don't want folks to think it doesn't go unrecognized. It's just, it needs to be done.
And it is a change for all parties.
Yes.
All staff is, they're receiving more documentation that needs to be logged and sent out to the attorneys. The attorneys are having, from every angle, the attorneys are having to review more information. So everyone has definitely stepped up.
And I know we'll get to it, but I'm certain I'm going to hear from the family counsel, Judge Foster and others, what happened with the information dump. And I think it's the best way to classify it, because there was that piece that's hopefully doesn't happen again because of the processes we're putting in place. But how that is going, because I think that's going to be the thing that slows down these appeals for a while, because you folks have finished your job. Now someone else is having to review them, and then a judge is going to have to review it from there, depending on what the parents, judges, or a counsel asked for. So I know I'll hear from you folks, but I know that it's what's happened as part of this delay. I think is the work has moved from one group to the next, and it's a lot of work.
And we have had, I would say, less than 10, probably 6 or 7 requests from parents' counsel or children's counsel to have something set aside. So we'll have to work through those. Those won't come back to you yet until that part of the process gets worked out. But it's just been a handful of cases. So
An important handful. That's why I'm here. I will never say one is,
absolutely.
And I know you understand that, having represented the families. Anything else you were going to add? I took you off track with yours.
No, you're fine. No, that's, I think that's pretty, Ms. Kelmer does have the specific numbers for each county if you wanted to have those numbers. But other than that, we don't have any additional.
And if we could, it would be helpful to just file in the case that's public, that information, that report of where that information is. That way, anybody who's not here or somebody trying to take notes, has it already been filed in there?
No, I apologize, Your Honor.
All right. I think we talked about that the last time, but
I apologize.
I'm not somebody who's going to yell or scream, at least not yet. All right. If you needed to leave, that's fine. I know you've got a meeting. Are you folks okay with that?
Thank you.
Mr. Foster, and I'm sorry I've drawn a blank. Did either of you have any questions or anything you wanted to ask her before she left?
Not at this time, Your Honor. I just had one.
Sure.
In terms of cases where they've had motions to set aside, how many of those were Maricopa County?
They were
all Maricopa County.
Thank you.
Thank you.
Thank you so much for
Have a
letting
good
me
day.
get out.
I understand. I've worked in that office too. All right, then I think what we were going to do, if we go back on our schedule, is we were going to hear from Ms. Patak, just really where things are at. Part of what I want to know comes back to, and I was wondering if anything is being held up still because of redactions, or whether and what the backlog, because I think that's always one of the places where things can get caught up and slowed down. So the specific question I have is the redactions, but updates from your perspective, and I know we'll probably hear from Mr. Hinsey more on the progress he made. It sounds like significant progress.
So as far as
I want to talk a little louder because that's the mic.
So as far as the redactions, I have not been hearing anything about them being delayed. their volume has increased significantly, but we're offering to anybody who wants it to stay and do that. We're also, we have a plan to bring on some temps. The good thing about temps as opposed to adding FTEs is you can ramp up, ramp down. And one of the challenges we have with CRCU is that you have to know how to do it, which takes some time to train. So the plan for the temps would be that they would do kind of the 1-pagers, the 2-pagers, the ones that are, look for social, basically. And then free up the time from our more experienced redactors to be able to do the 10,000, 12,000 page, whatever that comes through. The update, you shared it, but I was very, very excited that we met the deadline. Maricopa County people, up to the last minute, we were working, but we met it. And Andy has the exact numbers for what's outstanding, but that's the plan for the redaction to try and make sure that we're staying on top of it. Did you ask me another question that I forgot?
Was just any other updates that you had? I suspected that you were going to hand some of this over to Mr. Hinsey to talk about exactly where we are. Maybe, and I don't know how much you're involved in the meetings with the Parents Council to talk about, the documents and the data points and where that process is. I know we talked about continuing that over the holiday season as well.
Yeah, and those have been.
Yeah, I can give the update on that.
You'll need to make sure that you give a look, pretend you're trying to make sure they hear you and they're going
fair
like
enough.
this.
Thank you. Yes. Yeah. The app did go live, so that is good. We got very close, 23 hours close to missing the deadline, but we did make it. So I do just want to say that I appreciate the recognition to me, but it's not me, it's the team, right? So there's a lot of folks involved from our DCS IT. Thank you.
Thank you.
I appreciate that. Please keep doing that if I miss it. So our DCS IT, our partners at IBM and our partners at Microsoft all put a lot of work in over this holiday to make sure that that deadline was hit. So it is live, it's working. Kirsten mentioned there were 3 bugs that we found right after it went live. We fixed all 3 of them already. They were minor formatting things. None of them were about missing documents or any information. It was boxes that were overwriting a word. So you would read the word there and there'd be a square box on the T. Very strange, but you could still see it. One line got misplaced on a document to the bottom of the page instead of the beginning. So little small issues. 2 of them resolved Friday, 1 just this afternoon. So now we have seen 500 of these packets be created so far. There's over 150 of them have already been marked as disclosed. I'm not sure what the largest is yet. The largest that I've seen myself has been 300 pages that's been included there. I suspect there are larger ones. We've been doing daily calls with all of the field operations employees to make sure that they're up to speed and they can ask their questions. They've been asking great questions about this process. And some of them have been receiving feedback on the formatting of them because it is wildly different than what we've disclosed before, but it is literally everything. So there's no question about are we disclosing all of the information in Guardian. 100% of it from those notes is there for people to read and review. And aside from that, we have some next steps that we're looking at in the inclusions around emails on how we can bridge that gap. I don't have a specific target date yet, but sometime this spring is when we're thinking we'll be able to pull that in. I do want to make sure that we give this new process about the month for it to settle. I'm expecting a lot of reactions from people as it starts to roll out. There is a lot of information. And if we need to make adjustments or improvements beyond this first 30 days, then we can come back and revisit and adjust things as we need. So that's the application side. On the review of tables, some of the night.
Before you move on,
sorry.
The text messages were an issue. And how have you been doing? I know you were looking at some potential software that could help with that. Because I know that is an important aspect to the case managers maintaining contact with people, but at the same time, disclosure is part of that. So how have we been doing with messages?
So currently, if folks are texting, then they enter those as case notes, so they'll be included in this disclosure. Future state, though, we have two solutions that we're looking at right now through a couple different vendors. to see how we can actually use those to pull it in and automate it a little bit more. We are anxiously awaiting the budget drop on the 17th as well for this to know which direction we're going. These solutions are expensive. We know we have to solve it. It's just a matter of which route we go and how quickly we can do it, depending on that budget side.
All right. And I do understand that is a challenge that everybody faces. So, all right. So at least if they are using the text messages and it's necessary, they're going into the case notes and they're getting disclosed so that people know what's going on. And the emails are getting disclosed in the same fashion
Same
at this
fashion
point?
at this point, yes.
And how is the plan for that email then, so that they don't have to keep trying to do that cut and paste?
Email's a little bit easier because it's all in our Microsoft suite of products. So that one we're anticipating by spring, we can have the links automatically done and included into the same disclosure application. So the way that we've designed it, as we pull more stuff in, we can just tack it on to the existing packet. So a lot of the lift that was done now is reusable technology, and we don't have to try to reinvent the wheel.
Excellent. No, and I appreciate that this is asking, and Guardian wasn't designed to do this. But you folks, I appreciate the creativity that's been done to take a system that wasn't designed to do this and create an overlay that lets it happen. It was something that needed to happen, and your folks, and I didn't mean to exclude them, include them in that thank you, because I suspect it was a lot of extra time to get this running. And then we just want to stay on track to make sure the rest of it happens. Because I think one of the places we could find a glitch is if it doesn't automatically go, we could have somebody who forgets to upload a critical email, and then we're going to have a problem. And I don't want to see that happen. And again, occasional slips will happen, but I think the more automated it can be, the better off we'll be. So thank you. You are going to go now in. I wanted to derail you for a moment so we didn't lose that. You were going to go into the data points and the documents and the discussion with council.
Yes, so we have the 1900 tables. Am I doing okay, volume line? A little louder. Okay, sorry. We have 1900 tables that we're going through. We have gone through 400 of them already. We took the last couple weeks off of that discussion, and then we're pulling it back in this week to start hitting the rest of them. It's not a fun exercise. It's very boring, but we have to go through all of them 100%. Otherwise, it will always leave the question of, did I need that last 10%? So I know that's been painstaking. I appreciate y'all's willingness to be there for these calls and to work through it. But I would expect that to be done before close of this month for the review of those tables for what they feel is necessary. That gives us enough burn-in time for this existing process, and then we can start thinking about what's the next table we're pulling in and how is that going to function.
Okay. And the 1900, does that include the documents and the data points, or are we just, okay.
Yeah.
Docs, tables and docs. I just want to make sure. I thought that's what you said, but I wanted to make sure. Anything else going on from your perspective? And I appreciate you probably had the time off to focus on that January 1st deadline to get it done.
It's part of the job.
Yeah, no.
But yes, there's one other point that I will share that is less appreciated, but anybody that knows the Guardian, when it went live, it did not go live well. It crashed several times, and every update that was done caused problems. This one went live, and Guardian has not skipped a beat. It is still running. We have processed over 500,000 data points already just since it went live without a hiccup, and it keeps firing and running efficiently. So although that is a very boring, mundane point, a big win to the back end work to make that function without crashing things.
I 100% agree, having worked on document management systems and CMS projects, that, yeah, if you had something go live and at this point you've only had 3 bugs and it was developed quickly, that is a commendable effort. And I appreciate that you're still working on the documents and data points. Anything you wanted to add? Anything you want to add? Because you didn't get a chance to talk.
No, Your Honor. I don't know if you want. Okay, so, and these are based on
Court of Appeals members. So from a dependency case, it could be different because there are sometimes multiple Court of Appeals cases per dependency case. So in Mojave County, there were 16 cases total. We've had 4 stays lifted. There are 7 that are complete and are just pending court hearing in the juvenile court. A couple we're still looking for our emails and redacting those, and then we have 3 new cases. And I just wanted to add about the new cases. We started looking at the affidavit process November 1st, and so even if there are rulings coming out, they could be rulings that still predate or are right around that October-November deadline or date. And so that's why we may still have rulings that sometimes they take 60 days.
They have up to 60 days and can ask for more time.
Right.
I didn't even think about that. So thank you. That is a good point.
So we could have rulings that still predate our process. In La Paz County, there were 2 cases, and 1, the stay is lifted and 1 has a hearing. In Yuma, there were 4 cases, and they all have hearings set. In Yavapai, there were 6 cases. 3 had stays lifted. 2 were still gathering emails, and then there's a new case there. In Maricopa County, my count was about 84 cases. 66, the department has completed their disclosure, and either stays have been lifted or the judicial officers in the juvenile court are reviewing the cases, or we have status conferences set. And so I didn't get a chance to go through and look at all of those individually. There's 7 new cases, and then about 10 or so we're still going through appeals. Those are my numbers as of today. And I'll get you that spreadsheet here, and I apologize.
No, quite all right. If we could, I think it's just helpful. It's helpful for the folks, public who are here to know, hey, where are the numbers really? It's also helpful for us, again, Patrick, and I'll give him a shout out off camera, that he does a really good job of also keeping track of all of these and making sure that we're staying on top of it. I think one of the questions is, could we be more surgical in the cases we stay? I think there's at least 1 case that we just lifted the stay because we figured out that we didn't need it. And so we are trying to not stay every single case if it's not necessary. If the issue in the issue could be resolved without having to stay it, we're doing that. And I would say for the Attorney General, if you look at it and say, oh, you really didn't need it here because, let us know, you'll file something, because we will lift that stay if it's not necessary. I don't want to stay cases unnecessarily. But for the most part, we have to stay most of them at this point, unless we have that issue.
And we're working through that too. It's kind of like we had a big thing moving forward, and it had all this momentum. And so now I'm trying to put a stop and say, okay, we need to look at each individual case before, reach out to the department, check the affidavits. So I am now starting a process to make sure we're checking before we're requesting the stays. But I have to kind of stop that motion from happening automatically at this point.
No, and I think we all want to do that. And certainly for the parents, they want to have that too. They don't want a case stayed unnecessarily and leaving everybody in limbo, including the parents. So, did you folks have any questions for any of these folks at this point? And we can come back to it if you want. And I'm sorry, I don't know who you are.
My name's Jillian Aha. I'm the Bureau Chief of the Pima County Office of Children's Counsel.
Oh, okay. Nice to meet you. If we have that before, I apologize.
No, I've been virtual.
You've been online. People are paying attention to this, which is important. Judge Foster, why don't I start with you and let me know where your thoughts are, how you see things going. Is there something we need to be paying attention to as we're doing this?
Well, we'll start with your first question first and get to your
Go right ahead.
The concerns out of our office is that we have some cases where the state has asked for continued stay or a new stay, where the parents just want to be done. Or there's a guardianship involved, we just want to have that done. And that there's a lot of uncertainty, anxiety that goes along with that, both by the adults and the children. And so, without any indication of where the end inside is, where's the end of the tunnel? Those are the social consequences of stays, technical stays, where parties don't have an issue. You were just talking about cases where there's really no issue or need for a stay, And I don't know if the parties, if I can go back and tell my lawyers, well, you can stipulate there's no further issues, perhaps, and move the case along in that fashion. Willing to do that, that might solve it.
I will jump in, and not to interrupt you, but I think it might make it easier. We've talked about being willing to do that. I think we did in at least one case. I think the bigger challenge is, as lawyers, you know, the person can say it, and you can say, but I can't tell you everything that's in there, so make sure that you're doing this knowingly and intelligently. But if you have folks who really say, look, just let it go, the question is, I'm not sure how, if they're appealing, why they wouldn't want to get that other information. But if you have a client who says, yeah, no, let the appeal go as it is, I will entertain that. I will tell you. I'm not going to say I'm going to rule it or grant it. I'd have to look at the particular case, of course. But no, please do that if that's the situation that you find yourself in.
Just some other logistical problems, not so much on this end, but probably more so in trial court. In our office, we've had several cases where, for example, Judge Bustamante would hold her status conferences, and she sends a calendar, and I get it, and I forward it to everybody in my office. Look at this, see if you got a case. We've had a couple of situations where people said, yeah, this is my case, but I never got reappointed. And that's the problem. Okay. One case where there have been issues, and they're still looking at them. I think the client wants to set aside as a result. But I've had several lawyers say, like, I was never reappointed on these cases. Fortunately, I attend all those hearings, so I appear before them and said, like, don't send these back yet. Because
Your Honor, I'm sorry, but we're having real.
Could you try and speak up a little more, Judge Foster? I asked if we could use the microphone. Unfortunately, we can't, like the handheld.
all right.
So if you could just try and talk a little louder. Sorry.
And so where we have the situation where our attorneys aren't notified that you've got a case that's come back from the Court of Appeals, that's the problem. Okay. We've pretty much resolved that internally. To the extent in the future we have other cases coming back for whatever reason, just want to make sure that that happens. The other matter comes from our appellate department, and I'm sure Seth will talk about this as well, is when the judges at the trial court level make their determination that these documents are not going to make any difference in a case, there's a concern about, okay, for the appellate attorney, what is the record below? And that question is raised because those documents aren't made part of the record. And so, I've been asked for some direction about how to proceed with that. And, it's kind of case specific. But insofar as best practices are concerned in this situation, and I fully realize it's a new situation, it hasn't really come up before, where a case comes back on remand because new information, at least not juvenile. What are best practices at the trial court level, to the extent anybody needs to or wants to make an argument about that finding? We've had some findings that were made where there was not a hearing. That raises other questions regarding due process. So those are the sorts of things that...
all issues we're going to have to litigate, I suspect.
We'll have to litigate. But I wanted to mention those things and bring them to the attention of this body so that everybody can be on the same page about how are we really doing this. And as you know, and I know, having sat on our bench of 98 judges, all of whom have different ways of doing things, that we have some consistency as to how that happens, as to how the determinations are made. Because otherwise, like you say, we have to litigate it. What I'm saying is, let's avoid the litigation if we can.
Can I ask a question? Because I think I would just expect it to be made a part of the record in terms of at least somebody says, Your Honor, would you admit these exhibits for purposes of the record on appeal? So that, and there could happen in two ways. The state could come in and say, no, we think the judge is wrong, bring a special action, or even later in the appeal say it shouldn't have gone to another hearing. Or, the parents could bring it up and say, you're, Court of Appeals, the judge was wrong in his ruling, it really would have made a difference. Are they making or motions to asking the court to admit them for purposes of the record? Because one, I think that's important. I'm not going to disagree. I will tell you that as a trial court judge, I was well aware of it. And certainly now that I sit up here, where people just don't make something a part of the record, they don't admit an exhibit for that purpose. Are folks asking for that? Is it being refused? Or is it just not, we've got this problem of consistency?
Judge, I remind people of what you said when you appeared in our court about making the record below. Okay. Now, I remind people in our office, that's the case, make sure you ask to have those documents received so they can be part of the record below to the extent you can challenge it. The bigger problem comes is if there was never a hearing, but a finding was made that these documents were not changed. At that point in time, the question is,
how are they getting to the court, though? Are they attached to a motion? I'm trying to understand why it wouldn't, at some level, be there to look at.
That's a good question. I don't know.
Yeah.
I've seen several orders that have been made. I said these documents would have changed, if anything. I said to the lawyer, I said, did you have a hearing? No. You didn't have a hearing. No, just got a minute entry. So that's the problem. And so with respect to any appeal, I guess someone could have a transcript of, I guess you couldn't even have a transcript. Think about it.
If there wasn't a hearing, there's no transcript.
Yeah. So you'd have, what I'm saying is, we want to avoid any litigation that says, motion for reconsideration, to have whatever documents the court looked at to make this determination be made part of the record. I mean, and that just slows things down, and nobody wants that. So that's my point as far as that's concerned.
Yeah, if we could come up with a process and maybe working with the AG that there's a stipulation that those be made a part of the record for purposes of appeal. I think it's in everyone's interest to have that because you don't know which side might want to do that. But from my perspective, I want it to be a part of the record. Maybe I never have to look at it because nobody challenges that ruling and we go forward with the appeal. But I think it's a ruling that could be challenged, but the record needs to be complete for that to happen. And we're not going to take something outside the record. So I think, yeah, if we need to have a meeting with folks to try and figure that out, I'm happy to do that, to just make sure those documents are a part of the record one way or the other. And I think, maybe a conversation we could have here today that the AG will be, not necessarily while we're meeting even, but just to say, hey, what's the best way to make sure that happens? But I think that's a critical issue. And I talk about making a record because if it's not in the record, it didn't happen. Go ahead. I'm sorry. I didn't mean to interrupt.
No, I was done. Thank you very much, Judge.
Okay. Counsel?
Thank you, Your Honor. So it's been a little confusing because generally I think I have now taken over the appeals within my office. Our former appellate attorney retired the first week of December, and so I've taken over. And generally we have appeals kind of in three areas where we have a very small number of appeals where the decision was issued. We were just waiting for the mandate to issue, and then the stays happened. We have some where briefing has been completed and we're waiting on a decision. Then we have some that there's been no briefing or transcripts, right? So the ones without briefing or transcripts, I think are a little bit easier. We can still do a motion to supplement the record. We can include them. Because to clarify a few points, the Attorney General's office is doing a notice of filing on the docket at the trial level, and that's how the court is viewing these. We did notice that there is some discrepancy sometimes, and that's just because some of the documents are so large they have to be paper filed. And when they're paper filed, they may get a little mixed, and the clerk does break them into parts to be able to scan them. So we have noticed that the disclosures that counsel are receiving may not be in the same order or have the same pagination as what is getting filed with the court. And so my office, we're really trying to work on that and doing Appendix Cs with anything that we file so that we're all referencing the same documents, just because there's a little confusion. And I get it, when you're dealing with 1,700 pages, it's hard to keep it straight. And I don't think our electronic filing system was made to do that because it is a little hard to access that. I've noticed on our end for the offices, we have access to ISIS, but I think ISIS really struggles to pull up that many documents. I can't even see what's filed with the court. It just doesn't download for me, but obviously we can go down to the clerk's office and look at it. I've had some other experiences like this last week, I think I'm the attorney who's on that appeal where you noticed you didn't have to grant the stay, so it was denied and just went forward. But that was one where the issue had already been decided. We were just waiting for the mandate to issue, and then the mandate issued. So, you know, I'm sitting at this situation where for me with my client, because I was out a couple days next week, came back into the office and it's like, oh, we got the trial court decision and the mandate is issued within a few days. So I'm viewing it as like a potential appeal opportunity because it's a new trial court decision. So, you know, just to get that review because she did want the review of that case. And so I just say that, like, I think there are solutions. It's just we maybe have to be creative depending on where they are at procedurally in the case. Because I do understand that until we have filed or brought anything, the appellate record is not going to be supplemented automatically. That's just not what happens. Someone's got to do it. It's just, I think appellate counsel will be, maybe have to get creative. I do think that there is also a difficulty for the other offices, and so I'll say this because Miss Jamie Heller is the one of the great appeal attorneys with Mr. Foster, and I was talking to her about this issue too. The issue that they have is she handles appeals for cases where the legal defender was not trial counsel. So they only handle appeals from contract counsel, and when they were trial counsel, they farmed those out to contract counsel for appeal. So you have these trial court proceedings happening and an attorney appearing and then an appellate attorney all trying to coordinate on these and no real obligation because they're not the same firm. And you can't force, you know, contract counsel to talk to you. So sometimes you run into that where I think you may have Ms. Heller on as an appellate attorney saying, well, I can't file on the trial level. I'm not the trial attorney. And so she just has to wait for the stay to be lifted and then she can do something. She's just kind of along for the ride. She can see these issues forthcoming and feels a little hand-tied if she can't make a trial attorney do anything. Our office, I think, is unique in that aspect that we do handle our own appeals internally. So less of an issue for us. I think we're able to manage that differently. So I think you'll just to explain and say it will look different and be a little creative sometimes just because we are all in different positions just in how we handle the cases and who's able to file what.
Is there some way for consistency, though, at least as far as having the documents be a part of the record? If the notice of filing, does that have them attached and it's part of the record that it's there?
It would be on the docket. I think you'd have to have the clerk reissue that.
Ask to update the docket, which is something certainly we can always ask for an updated, and I'm not going to speak for my clerk. I know we update dockets all the time. We ask people to complete the record in cases when we have an appeal that if nothing else, perhaps counsel for the appeal could say, could you please request an updated docket? But I will look into that. Patrick, I suspect, is writing that down right now for me. Let me see what we can do, because we regularly routinely request updated records. So I would hope that we would get it if it's attached that way. But I will double check that for the next meeting, and we'll put that, Patrick remind me to put that on the agenda to talk about how we're updating the record too, to make sure that we have everything from that, because I do think it's a different situation. I'm not going to try and resolve some issues, like how do we handle that? How is it a separate appeal? Is it part of the same appeal with a modified notice? Again, one of my cases was one that was stayed, and as soon as we lifted the stay, we issued an opinion. Sometimes it's just the mandate, and sometimes that's when the case really gets started. And so we do have kind of three different situations. That's going to change because I don't think we're going to have, within the next 2 months now, cases that are fully briefed and ready to have a decision issued, new cases that way. We should only have cases that are not even briefed.
I would agree. I think at this point, all cases that have been briefed or had transcripts issued have now been resolved, at least on this disclosure issue. Right. So if we are looking at any further stays going down another month or two, it'll likely be the ones that just don't have anything filed yet. So a little bit easier to resolve.
But it is a problematic. Did you have something to add on that?
No.
Okay. I don't know whether you're just here to listen and weigh in. Or...
I think luckily in Pima County, we don't really have this issue on the appellate level. You know, as Judge Starring said, kind of just an interested observer as far as the current situation with appeals. I think our bigger concern is moving forward, what disclosure is going to look like, and this kind of new case note process and the work that we're doing on that, I think is kind of our larger concern, and whether cases are going to be able to move towards permanency, you know, if we can't get these affidavits, and, you know, just interested in what efforts the department's making to make sure that disclosure will be regular and ongoing for all documents moving forward, so that we're never in this position again, I think is really where our concern is at this point.
I think that is where everyone, I mean, I 100% agree, and I again commend the department for acknowledging that this needs to be done, so we never get here. Have you had problems at this point? I know Judge Starring at the appellate level is in St. Mature, also looking at the trial level. How are things going there? Is it moving along?
I think at the trial level on our current cases, you know, we're not seeing disclosure of all documents like we would hope, but I'm hopeful that that will be corrected moving forward. I was just checking in with my kind of disclosure staff today. Today was the first day that they've really seen an uptick in the number of pages coming in at a time. We received our first case note, I think, last week in the new format. And what would have been a 1-page case note is now 18 pages. Page 4 had, I think, 5 relevant lines. Page 7 had a chunk that was relevant, and the rest of it is really nonsensical. And so I think that's a concern for us. You know, if that disclosure is coming in every 10 days, it's going to be a hassle to sort through, but manageable. But if we're going to be getting huge hundreds of pages at a time to wade through all of that, is going to be very time consuming and difficult. And so, you know, we've been kind of thinking about, you know, should we be asking for motions that case notes be disclosed in the kind of January 1st format? Because our read of the disclosure rule is that it should be in a way that's functional for everyone. So, you know, we're willing to engage in the process. We're hopeful that it's going to be workable for everyone. And I appreciate the department's collaboration on that. And hopefully, you know, moving forward, we can reach a solution that works for everyone. We have low case numbers right now, so we're not feeling a ton of pressure. But if those case numbers creep up, this could really become quite burdensome.
In that regard, and it's a formatting issue from some of it, and I think they were in a hurry to get the documents out. Formatting can follow. And have you had a chance to talk with folks about the formatting? Because I think part of what we're working through is now now you're going to get it. Now, how do you get it?
Right.
Have you had a chance to talk about that? I don't know if you've been a part of those discussions.
I have been a part of those discussions, and I've had phone calls with Ms. Wright as well about that. And so we'll see what's forthcoming.
Okay. Did you have something else before I go to Mr. Hinsey?
No, that's all.
And Counsel, you may have something else. I didn't mean to cut you off.
But no, I was just going to comment that because I know we talked about whether this was going to be burdensome. And at least at this point, I've not heard from our staff that it's been burdensome, which generally I think as long as they're coming in packets, it's not too hard because 1,000 pages is the same administrative burden as 1 page in a PDF. It's all just clicking and dragging one file. Obviously for the attorneys, that's more to review, but that's what we've all been asking for. And so far, we haven't hit anything that has been problematic.
And Judge Foster, Mr. Foster, have run into the same formatting challenge?
Yeah, but from a different point of view. You can call it a formatting problem or problem in the various differences between the documents. In other words, it's not indexed. You don't know if it's a case note or a service note or something like that. It just kind of comes, to use the word that's been used, a dump.
Yeah. It's the vernacular. It may not be a legal term, but it's a concept.
Yeah, and so part of it's formatting, and other of it's my subject matter.
And so, just Mr. Hinsey, and I know, again, I understand things have to happen in phases, and part of this is we're looking at having emails be separate at some point. We're looking at having text messages be separate and case notes they kind of be in their own thing. Is that formatting something that along the way, once you get the first heavy lift done, which is get it out of Guardian and actually in something that can be sent over, can that formatting be worked on and continue to be developed so that it is somewhat more?
Yes. I can't commit to a timeline of when that happens yet because we need to figure out how do we get all these things merged together. It is introducing at least 2 new technologies into the process that we need to make sure can be all merged and combined into this one PDF format. Because what we don't want to do is have it be 500 PDFs for people. Right. So like we know that there's wins and losses with all these things. There are some things that we'll be hitting on in the next weekly calls that we have with the folks here about how to use the current format a little bit easier and navigate it now that it's real and people can see it and search it. So I think that'll help a little bit in the temporary adoption of this. Depending on what it looks like when we get the text messages and emails all in there, that should tell us when we can start looking at the prettiness factor to this. I've said before on a few calls too that there's also the possibility of an injection of money. An injection of money also makes things go faster, right? So if that happens, then yes, we could potentially look at that. But my crystal ball is broken currently, unfortunately.
Mine never worked. Believe me. Neither does the magic 8-ball. I'm sorry, that little thing in there doesn't ever give me a right answer. So, and I would say it's not just a prettiness factor, it's also a functionality on the other side, but I understand what you mean. It's how does that work? And so I wholeheartedly understand what you're talking about. Thankfully, we are at a low period that we can keep working on it, and by the time, if things pick up, that we can get that taken care of. But that's a really good point and something that I think we need to keep talking about as we go forward, because one paragraph and trying to find it in 8 pages is a challenge. But again, the first thing was the triage to just get it over there. And I think that's a good thing for everybody to have it, because you don't know which one of those case notes is the critical one that's going to make a difference one way or the other as you're going through it. So, so what I'm thinking, and let me just ask folks, I don't want to keep bringing folks in here, but I also want to, unnecessarily, but I want folks to stay on. And I know that if we don't meet, it can become well, we'll deal with that next week or the week after. We put it out about a month. And are folks comfortable with coming and saying, look, let's come back in early February for the next meeting? That gives you time to hopefully be through about 1,500 documents and data points. So based on my math, 1,900 minus the 400 you've already done. It'll give you folks a month of this new information, and I think you're going to start to see what the regular weekly disclosure is, as opposed to, or 10-day disclosure is, as opposed to the massive thing that happened just now, to start to see how that's going to function, and we can have that discussion, and perhaps then we'll know more about the budget. 17th will have passed, in terms of getting the emails and the text messages, and perhaps you'll have a better sense of what process you can use for those. Does that make sense? I think I'm seeing a yes, so I'm going to gather that. We'll try and see. You can't check these conference rooms, and unfortunately my name is out. Lena's out, yeah. Oh no, she's working, but she's not in the office. Yeah, no, she's working. She should be able to check it. She's just not right here where I can say, Lena, look at this. I'll email her email review. I'm looking in terms of looking at my schedule, which I'm dangerous for me to try and do it without Lena. Folks, I think, tend to prefer the Tuesday. Does that still work for folks? I'm seeing a general consensus on yes. So if we used February 11th, let me start with, will that work for you? Yes. I'm seeing, and I don't know Ms. Wright's schedule. Does that work for you, Ms. Patek?
It doesn't work for me, but I can see
that. If you're comfortable with that. Okay. Would another day that week, or is it that week that's a problem?
No, it's just that day I have someone coming from out of town for a meeting at 3. Well, it's at 3 o'clock, so if we did earlier?
Yeah. Oh,
If I could leave by like 2.
well, and we could do like we did with Miss Wright, that we can do it and you can take off when you need to, if that would work for you. Okay, so let's see if we can get this room. If not, we can probably get 119. I do think this room works better overall. We'll move people in so we're a little bit closer, so hopefully hearing won't be as much of a problem. We have a handheld mic, but I guess it doesn't work in certain situations. Are we waiting for Lena to check? Okay. I think that's the best way to do it. In terms of making sure we all keep track of things, give me just a second so I can ask Patrick a question while we're waiting. One thing that I think will be helpful, and I just asked Patrick to make sure that he could easily do it. We're keeping track on our side, and you're keeping track on your side, and you're keeping track. I'm happy to share our list of appellate cases that we're looking at. If you folks are willing to do the same, again, we'll sterilize it so there's no work product or thought in it, but just let's make sure we all have the same list of cases. And the reason I'm suggesting that is just Mr. Foster and others have mentioned, sometimes the attorneys don't realize there's a case that they should have been appointed on, or perhaps because this just isn't on someone's radar screen. If we share that list, I think it would be helpful so that everyone knows, hey, these are the ones that the Court of Appeals is at least looking at. And then maybe that can help avoid that problem. And we can probably get that out here in a couple of days for you folks so that you can have our current list. The other thing would be helpful is if you let us know that there's a case that we should be paying attention to in this process. Let us know in an appropriate way. We can show you the cases we're tracking without a problem, but in an appropriate way to make sure if there's something that should be on our list and somehow we have missed it. And again, going back to, I think, Ms. Wright's thing, we're not perfect. It's a human process, so we may have missed something that we're trying hard not to let us know, so we get it on our radar screen. I'm thinking that over the next couple of months, this is all going to trail off. We should have these moving, and I'm hoping by April we're pretty much running, and then we're just meeting about making sure that the rest of the disclosure is happening, and we can let you folks actually move on, and we won't have as much of a problem. So have we heard Jeff? All right, so February 11th, we'll be back in this room at 1:30. Ms. Patak, you'll go. Yes.
I have that was possible court procedural changes. I'm curious if that's something that was meant to be talked about, or are we skipping that intentionally?
It sort of comes up when everyone talks. Is there something we can do? And a part of what we were talking about, and what I consider to include that, was the discussion about how the documents are becoming a part of the record and making sure that we have them in the record. Were there any other procedural? And so it didn't come up separately. It just came up in the general discussion. So I'm not trying to skip over it on purpose. Was there anything else?
It was the matter of ensuring that counsel reappointed.
Okay.
Counsel being reappointed in
Correct.
Trial level, which was part and parcel of that discussion.
I'm sorry. And the challenge is I can't really order the Superior Court. I do a lot to try and make that happen. How you talked about it, but are we really running into a problem where the courts are simply refusing?
No, I'm not saying they're refusing at all.
Okay.
I'm not saying they're refusing at all. It's just that maybe it's something that's slipping through the cracks. I'm not sure.
And that's why I think it's important. If we share our list, then look, these are the cases, and trust me, if we state a case, it's on our list. If we state a case, then you folks can look and go, oh, we've got an attorney on that case or a contract attorney. We need to make sure they know so that they can actively try and get themselves, or somebody can try and get them reappointed.
Your Honor, we generally are filing motions for reappointment when we file the documents. In the Maricopa County cases, the court started automatically issuing minute entries, reappointing counsel. But sometimes it's not clear if it's both parents or only the parent who may be appealing. And then in some cases, we have a JS, a severance matter separate from the JD. So sometimes councils reappointed are only one. So I'm doing my best to sort through that and file motions when needed, but you can definitely let me know if I need to file a motion. We have no issue filing those motions. It's just, as you said, like keeping track of them.
You know, our appellate lawyer, Ms. Heller, was telling me that her name is appearing on the remand to trial court. But the
Which
trial
is
lawyers,
appropriate because she's the counsel here.
but the trial lawyers weren't noticed.
Yeah.
Yeah, so it's, like I said, I think there's some confusion. I'm not sure exactly what it is. I think
wondering
it
if
needs to
we-
be resolved.
We get that list out there, people can all do a little bit more of a focus and say, look, did we get the right person appointed procedurally? Because I know at first it wasn't happening, and I know I had to issue some orders. Again, I couldn't force it, but that's, I think, resulted in the trial court making those appointments once those orders started going out. So I think they're open to doing it. It just may be a glitch where they see Ms. Heller's name or maybe some other appellate attorney's name and forget that they need to do that. And I'm going to be honest, as a trial judge, I easily could have made that mistake.
We're trying to include everyone on all of our pleadings, but it varies as who reviews the pleading if we catch it. And so we are trying to include everyone.
Yeah, and you know, Judge Bustamante was very open with respect to those lawyers whose clients did not appeal, to excusing their appearance from the matters because it's not an issue for them.
If they didn't appeal, arguably there's no issue anymore, unfortunately. There, you know, whatever else may come of it.
Exactly.
If they did not raise an appeal, because we're not trying to revisit every case that didn't have an appeal at all. You know, and so that, you know, I don't want to see us starting to appoint a bunch of counsel for people who didn't appeal at all, and who are not engaged in the process. That would be problematic, I think, for all parties concerned, including, you know, especially the counsel for those folks. So if we could just make sure, if there's something I can do, file something, be in the 61 case or in the specific case where there's a resistance. But I know my experience has been, what I've been seeing is counsel are getting reappointed now pretty smoothly. But it sounds like there may be some glitches. Again, one that I easily would have made if I was trial judge and would have appointed the person whose name was on the piece of paper.
And just as a practical matter, there are times where multiple attorneys have represented the same party. And so sometimes it's just a matter of figuring out who the most recent person was, honestly. I mean, going through a lot of minute entries. So.
I don't want to rub salt in a wound, but it's kind of like caseworkers. Attorneys for the parties can also change on a regular basis. And that's why sometimes the CASA is the most consistent person, because the judges change and it's hard for those folks all the way around. So I hope that answers your question, and I think we hit it. Was there one procedural question in particular?
For Maricopa as well as Green Mountain County is there are moments where lawyers were removed from the contract and the justice in the interest of public taxpayer dollars. And so then there's an awkward situation of where no longer on our contract, now have to pay again or have removed in an awkward situation. And I think that the judges obviously normally don't have to determine whether this lawyer is still the appropriate person to appoint counsel, and intake units in those courts. Each court has an intake unit of time for it. Generally, has a better understanding of that. And or if AZ just CAT went into contract, I think that would potentially be another way to resolve it. Although I really think the courts have a process. It's just that the trial judges are not normally the ones who are doing that intake process. So
Sure.
I think from that standpoint, the courts just following that kind of a process might be a better way, almost as though you're filing a petition. We don't need a petition file, but I just think that that's probably the better process.
I wonder if, and because it's an important point, but probably not one to try and solve here, talking across the room, maybe we can talk afterwards and talk about how we can try and, if there's a better way. And could you, because this isn't an official meeting or anything, but who are you? Okay, thank you. I appreciate it. And you're welcome to sit up here at the table.
I tried that.
All right. It sounds like a discussion that probably should happen if there's a better way to try and make sure we get the right people appointed. So let's chat after we're done to say, okay, and if there's somebody that we should endorse, we can endorse, but I don't know that that's the right solution. But that may be. So let's talk afterwards. So thank you. I appreciate it. All right. So I think we're set for the next meeting. What I'm hoping is, again, we're done with all the document review. We have a sense of what's going on with the ongoing disclosure, that things have settled down, and that we can keep the process moving forward. I appreciate everyone's time. Wish you well over the next couple of weeks. Wish you well with your budget request, Ms. Patak, Mr. Hinsey. That's never fun. We'll talk afterwards right now about that issue, just to see if there's, who folks think is the right person. And I don't think it's necessarily the people in the room, because you're with, yeah, it's probably talking with the court. And Judge Bustamante and I have talked, and maybe we need to have that discussion a little bit more focused on that one issue. So thank you for bringing it up. All right. Thank you, folks. And we'll see you on February 11th, then, 2 days before Statehood Day. And 3 days before Valentine's Day and Statehood Day. So thank you.